Good morning, everybody. My name is indeed Frederik Borgesius, working since 2 months at the University of Brussels, and I have the honor of making some introductory remarks about data protection law, where that intersects with the rules for intermediaries. And I'll end the presentation with some good news for everybody. Everybody in this room, everybody in Europe, has at least various fundamental rights, including a fundamental right to privacy and a separate fundamental right to the protection of personal data. And that second right, our right to the protection of personal data, is a bit more modern invention put in the EU Charter of Fundamental Rights in 2000, which is valid law since 2009. So the EU Charter has all the traditional human rights, a right to freedom of expression, right not to be tortured, etc., and a right to privacy, which it basically almost literally copies from the European Convention on Human Rights, so nothing new there. But also the more modern right, which grants everybody of us the right to the protection of our personal data. In practice, secondary law plays a larger role in the daily practice of attorneys and firms dealing with personal data. Nowadays, still for 2 months, we have 28 national data protection acts, all based on the Data Protection Directive. But from May this year, so 2 months left, the General Data Protection Regulation applies in whole Europe, the GDPR. The GDPR does not prohibit dealing with personal data. The GDPR assumes that in a modern society, personal data are used and have to be used a lot, and includes lots of rules, more than 90 provisions, on how that hope to ensure that personal data are dealt with fairly and in a civilized manner. But today we talk about intermediaries, and the GDPR makes a confusing remark, slightly summarized here, that the GDPR is without prejudice to the application of the liability rules of the e-commerce directive. So something like the GDPR does not influence the safe harbor rules in the e-commerce directive. More confusingly, the e-commerce directive says pretty much the mirror image. This e-commerce directive does not apply to questions relating to internet services that are covered by the GDPR. So you have 2 sets of rules that appear to say, I don't mess up that other set of rules. And I've been struggling this week because I always put this on the list of, oh yeah, this is something that I should write about sometime together with a colleague who is good at intermediary law, because this just gives me headaches. I'm still at that stage, to be honest. I feel a bit less stupid because David Erdos, who's going to give a talk later on today, he mapped out in a lot of national member states how judges and courts deal with that interplay. And his conclusion is it's a mess. It's unclear. For instance, you could argue that Facebook is a host. You could argue, and Facebook does argue that in court cases, but you could also argue Facebook is too active, etc. So, messy. That is the best conclusion. And for more detailed questions, I'll refer to David Erdos. Another situation, a specific situation in which data protection law and intermediary rules interact is the case of search engines. As many of you know, there's no specific safe harbor in the e-commerce directive. There arguably should be, but there is not at the moment. Many people that I know think that there should be some type of safe harbor provision for search engines, and many assumed that there even under the current rules you could read something, you could apply them by analogy or something, and some countries have in their national law some type of safe harbor. Many people had the same assumption for search engines in the context of data protection issues. Even, by the way, the so-called Article 29 Working Party, which is 28 data protection authorities together, even they, and they tend to be pretty activist and pro-privacy, but even they said search engines are only partly liable for the stuff they do with personal data. But then, 4 years ago, this gentleman started suing for years and years and years, and he won the notorious right to be forgotten case at the Luxembourg court. He's happy, he won. And, surprisingly for many people, the EU court said Google is a data controller, and a controller is the data protection law phrase for, very roughly summarized, the entity that is responsible for compliance with data protection law. And the EU court basically said, if Google acts like a search engine, in cases where people look for a name, for instance, Frederik Borgesius, if you do a search for Frederik Borgesius, in that case, Google is a data controller. And that means, in principle, that Google must comply with data protection law. There are many problematic aspects with that conclusion, and the Advocate General had warned for that. The court didn't listen. But this is roughly summarized the situation. There's no safe harbor for data protection law for a search engine. Even more extreme, you could say. Google is actually a data controller as far as it deals with personal data. This case law, the post-Google Spain case law, is still developing. And then a last topic, where also data protection and privacy issues and intermediary rules interact. Should intermediaries disclose subscriber data if copyright holders ask for that? And this is a relevant question because in many countries, copyright holders look around on the internet and see the IP address of people who upload movies or who just exchange files. For instance, in Holland now also the film industry is planning to go after people who exchange movies, and these people are at first identified by IP address. And then the next step, if you want to sue them, or if you want to ask for money, you have to go to their access provider and say, I have here IP address 123456, please give me the name and address of that person. Now, such a case made it to the EU court in Luxembourg, a Spanish case. ProMusica, copyright holder, asked to Spanish ISP, as I just explained, we here have IP addresses of people that we suspect of file sharing. Give us their names. I'm roughly summarizing here. There's some stuff with national law that I won't go into now, but ISP basically said, no, we won't give that. Went to the EU court, and the EU court said, well, there's no requirement for the ISP to give this subscriber data. But there's also no prohibition. The EU court basically said, in language that it has been repeating a lot since then, you should strike a fair balance. So that is fair and reasonable, but I could imagine also a bit disappointing for national lawmakers and judges, because the EU court basically gives the problem back. Since then, there was, 2 years ago, there was also a German Coty case, and there the conclusion from that seems to be a full prohibition in national law to ever disclose such subscriber data is not fair. So now we have one more example of what is not a fair balance, but what exactly a fair balance is basically mostly a problem for national lawmakers. But, as I said, it was all unclear, but I will end with good news. And I have good news for academics. There's much more books and papers to write. And good news for lawyers. There's much more advice to write and much more cases to do. Because the relation between data protection law and intermediaries remains messy and complicated. And I'll leave it at that. Thank you very much.